Thank you for joining me. My name is Marc Fitapelli. I'm a New York City-based attorney. I represent investors in securities arbitration cases nationwide. I'm here today to talk with investors who purchase GWG L Bonds through Western International Securities. And more specifically, what I'm going to do today is I'm going to review the complaint that the Securities and Exchange Commission filed in June against Western International. I'm going to go over the allegations in the complaint, and I'm going to also explain how that complaint may affect investors who have already filed or who may be thinking about filing an individual securities arbitration case against Western. Before I get into all that, I just want to put up a quick slide of disclaimers. I'm not going to read through all of them. What I'm going to do, though, is just let you know what's important about this. What's important is this is attorney advertising. I'm not giving you legal advice. And number two, everything I discussed with you today about Western International is based on a complaint that the Securities and Exchange Commission filed. It's based on allegations. There's been no finding of fact and no finding of wrongdoing by the SEC or by the federal government. So with that being said, I just want to give a very brief introduction about what's going on, about the situation. I'm here discussing GWG L Bonds. L Bonds were an investment product that was offered by a company called GWG Holdings. GWG Holdings filed for bankruptcy this year. They filed April 20th, 2022. They filed for Chapter 11, which is reorganization. In a few weeks, I'm going to release another video. The video is going to be a summary of what's happened in the bankruptcy, and it'll also address GWG's plan for reorganization. We're waiting for documents to be filed with the bankruptcy court, and we're waiting really for the bankruptcy, for more of the proceedings to transpire. And once that happens, we'll update investors, and we'll do that through a video and a press release. On June 15th, 2022, the Securities and Exchange Commission sued Western International and several brokers for selling GWG L Bonds. And what I'm going to review with you today is that complaint. The most important thing I want you to understand about that complaint is that the government is suing GWG for disgorgement of commissions, which basically means the return of commissions, and other civil penalties. It's not seeking the return of individual investors' investment. And that's something that's very important. If you're watching this, and if you've heard that the SEC has sued Western for GWG L Bonds, understand that that lawsuit is not going to result in you receiving restitution or return of your principal. And I could say that with confidence because I've read the complaint, and nowhere in there does the government ask for that. What they're asking for is the disgorgement of commissions or the return of commissions and civil penalties. And what typically happens is those civil penalties are usually paid to the U.S. Treasury or directly to the Securities and Exchange Commission. There's no restitution in this case. So investors need to file individual arbitrations, and they need to seek out their own attorneys. So what are the key points, or what are the key takeaways from the government's complaint? And these are my three takeaways based on my reading of the complaint. Number one, brokers at Western International Securities didn't understand or didn't care that GWG L Bonds were high risk. Number two, the brokers at Western International ignored important issues regarding GWG L Bonds or simply didn't understand them. And number three, Western International had poor internal controls and supervision over its brokers. And I'll go over each one of those issues, and I'll show you how the SEC establishes that in its complaint. So in another video that I released prior to this, I explained how GWG L Bonds were high risk. And if you don't believe me, you can look at the cover of the prospectus, and it says in big bold letters that they were high risk. When the SEC had filed this complaint, it actually had a unique opportunity, something that plaintiffs' lawyers don't have. It had the opportunity to depose brokers from Western before the complaint was filed. Usually when plaintiffs' attorneys, when private attorneys file complaints, we rarely have the opportunity to depose the other side's witnesses before filing a complaint. Usually depositions come later on in civil litigation. Here, I guess because you're the government, you get an advantage. So the SEC had the opportunity to depose brokers, and this is what some of them said when they were asked if they knew about GWG being high risk. One of them, quote, did not consider L bonds to be high risk, instead describing them as relatively safe, unquote. Another knew they were high risk, but, quote, disregarded that disclosure. And so very concerning, right? Two of them didn't know it was that the investment was high risk, and one just didn't care, right? And those were the three brokers that the government talks about in the complaint when they talk about the fact that representatives from Western didn't know or didn't care that GWG was high risk. Another issue that the SEC discusses in its complaint is the fact that GWG L Bonds were not directly secured by collateral. Now, the specifics of this point aren't important. So the mechanics of it, what's happening, aren't important. What's important is what's highlighted on this slide. The value of GWG's life insurance portfolio was not sufficient to repay all of GWG's outstanding debt, right? And so that's a fact. That's something that is true. And what did Western International's brokers believe about this? Or what do they say about this? Or what do they do about this? They failed to appreciate that life insurance policies themselves did not collateralize the bonds. What does this all mean? They didn't understand this. They didn't understand what they were selling. These investments were complicated. There were complicated features about them that made them high risk. There were disclosures that warned that investors could lose all of their principal. And those disclosures and those warnings were true. And what this means here, in very simple terms, is that the brokers who sold this just didn't understand it. And that's what the SEC is establishing with this complaint. One of the other things that the brokers just didn't understand is that GWG wasn't profitable. And the next slide that I'm going to put up for you is paragraphs 87 and 88 of the complaint. And you'll notice these are later paragraphs of the complaint. Before these paragraphs, the SEC does a very good job of walking the reader through GWG's filings with the commission, and those filings show, for example, history of net losses, right? Net losses in year ending 2018. So it shows, with all the information that was available at the time of sale, basically, you can look at these financials and you can see that GWG was not a profitable business, right? So what do you do with that information? Well, you ask the representatives, did you know that GWG was not a profitable business? And look what they say here on these slides. One of them knew little and did nothing to educate themselves, and the other one just erroneously assumed that the business was profitable. So again, the government had the benefit of doing depositions and had the benefit of taking testimony from brokers, and the testimony is disturbing, right? You know, some of them just didn't know, and some of them just assumed the wrong information. And these were people who are selling tens of millions of dollars worth of investments to retirees, and people who shouldn't be risking or shouldn't be gambling people's lives with their lack of knowledge. And so, what internal controls did Western have? And the SEC does a good job of going over their lack of internal controls. So these are paragraphs 56 and 57 from the complaint. So apparently Western's compliance officer ordered a due diligence report. A due diligence report is a report from a third party reviewing the risks of an investment. So typically when brokerage firms sell complicated investments like GWG, what they'll do is they'll engage the services of a third party company to do due diligence. So look at the things that I just discussed, the financials from 2019 that showed net losses, the complicated ownership structure. They'll hire a company, lawyers, accountants, a company that's sophisticated enough to perform that review. And in Western's case, only one person reviewed that report. That one person was the chief compliance officer. The report wasn't shared with not a single registered representative, not a single supervisor, not even other compliance personnel. So that's pretty unusual in this situation. The other thing that's unusual is that the prospectus for GWG stated that the bonds should only be sold to customers who, quote, had substantial financial resources. So even though that's what the prospectus said, Western had no policies and procedures in place to restrict the sale of L bonds to customers with certain risk profiles or investment objectives. What does this mean in layman's terms? If you're watching this and you're a conservative or a moderate investor and you were sold GWG L bonds by Western, you shouldn't have. That's what this is saying, that Western did nothing to restrict sales of L bonds to people who had moderate or conservative risk tolerance, or whose objectives just were inconsistent with GWG's high risk. And so, what are the key takeaways and next steps for investors? So, number one, and I think that this is fairly well established, the brokers from Western didn't understand and often misrepresented the key features of L bonds. And it's my opinion that they were negligent or worse in this regard. Number two, Western International will probably consent to a civil fine. And this civil fine, remember what I said earlier, is not going to involve restitution. It's going to involve disgorgement of commissions and a civil penalty paid to the U.S. Treasury or the SEC, not money going back to investors. Number three, customers of Western International, because of number two, what I just told you, must hire an attorney to seek compensation from Western International Securities. The government's case is not going to result in restitution to individual investors. So if you have any other questions about what's going on, if you're a customer of Western International and you're considering filing an arbitration case and you want to know if your situation qualifies, give us a call. Our number is 800-767-8040, or you can visit gwgcase.com. And on that website, I have the other video that I referenced in this case, that other video that discusses just a basic overview of the FINRA arbitration process and a basic overview of these cases. Thanks for listening.